Good morning. I'm Mark Kimball, Chair of the Citizens Clean Elections Commission. It is 10:30 a.m. on Friday,
Friday.
August 14th, 2026. I call this meeting of the Citizens Clean Elections Commission to order. With that, we'll take attendance. Commissioners, please identify yourselves for the record.
Ellen Page.
Christina Werther.
Sam Crump.
Christina Werther. Sorry.
Good morning, Steve Tidla.
Good morning. We have all five commissioners with us this morning. Also present are Tom Collins, the Executive Director of the Arizona Citizens Clean Elections Commission, and Craig Morgan from Taft Law, acting solely as the Commission's independent legal advisor. Item 2, review, consideration, discussion, analysis, and possible action on release of clean funding to Dr. Ralph Heap pursuant to AAC R2-20-106A and AAC R2-20-106G, and August 7th request to withdraw as a participating candidate under the Arizona Citizens Clean Elections Act. The purpose of this special meeting is to consider a request we received from Dr. Ralph Heap regarding the Commission's August 4th decision denying Dr. Heap's request to withdraw from the Citizens Clean Elections funding program. For those of you joining us in the meeting and the live stream, the order of this item will be as follows. First, we'll hear from Tom Collins, Executive Director of the Clean Elections Commission. Next, we will hear from Dr. Heap or whomever is appearing on his behalf. Next, we will take public comment on this item. Please keep your mic or your phone on mute until we ask for your comment. I want to note that the Commission has received a written request from Dr. Heap's lawyer, Mr. Timothy Lasota. One member of the Commission has a hard stop at noon, so we will be mindful of that and manage time accordingly. At any point, the members of the Commission may vote to go into executive session to seek legal advice from our independent legal advisor, Craig Morgan. Depending upon the complexity of the issues, we may go into executive session more than once. Neither the public nor Mr. Lasota nor the executive director will be permitted to enter an executive session. I will start by asking Tom Collins to discuss this matter. Tom?
Thank you, Mr. Chairman, Commissioners. I'm going to principally focus on what I think is the upshot of the agenda item and the issue, which is the filing of the affidavit under Rule 106A with respect to the release of funding. Since you all last met, in fact, I think it was yesterday, Dr. Heap submitted the sworn statement that 106A required. So you recall that the Commission has a rule that says before staff can release funding, a candidate has to file a sworn statement notarized that says that they have filed all campaign reports, that those campaign reports are complete and accurate, including with respect to vendors and sub-vendors, and that those reports are compliant with any rules on consultants. And finally, an issue that's not present here, that they understand that going forward, if they were to fail to file a campaign finance report after funding, the Commission staff could initiate repayment proceedings. So we received the form, and as I communicated to Mr. Lasota and the Commission in a letter early yesterday, I don't think that resolves the underlying question under Rule 106A, and I think there's a substantial question before us under Rule 106G. The difference between Rule 106A is that it's the direction to staff. 106G is a Commission decision to exercise its discretion if it chooses to not release funding in the event there is evidence of illegal activity. So what we now know, we also have the response that Mr. Lasota filed respecting the reasons of the complaint, MUR 2606. And I recognize that that's another agenda item. And obviously, you all and Mr. Lasota should have received a recommendation on that as staff. So I'm going to focus my comments here on Rule 106. Obviously, the facts as outlined in the MUR response are relevant there, but I'm going to focus principally on that, and then when we get to the MUR, I have additional obviously things that I think that warrant staff weighing in on. So first starting with Rule 106A. Rule 106A says to us, the staff members, don't release the money unless you have this signed sworn statement. And we have an issue of first impression, where whether filing the statement itself requires the staff to release the money, when the staff has reason to believe that an aspect of what was sworn to is not true or accurate. In this case, that all campaign finance reports are complete or accurate. And I don't believe that the rule can be read to state that the staff should ignore any other evidence in the face of the sworn statement. Because the rule doesn't merely require the form, it's establishing conditions for the release of public funds. So filing a sworn statement is necessary, but the statement doesn't conclusively establish its own truth. And if staff has evidence that there's a material campaign transaction that's missing from the reports, the fact that the candidate has sworn the reports are complete doesn't eliminate that evidence. Otherwise, the substantive requirement that reports be complete and accurate doesn't serve its purpose. And the commission staff will be required to release public money whenever the candidate signs the form, regardless of what commission staff already knows. And given that 106 is a direct direction to staff, I don't think that that's a I don't think that can be a rational reading of it. So on 106A, my recommendation is a pretty narrow one, where the staff has reason to believe that the reports are not complete and accurate. Rule 106A permits, or at least it requires, staff to continue withholding funds until that condition is resolved. Rule 106, and so I guess, Mr. Chairman, if you'd like, I can stop there and we can talk about 106A, or I can continue on 106G.
I think we'll take the second item. We'll just limit ourselves to this first item right
Okay,
now.
so I'll keep going on 106G then, which is
Okay.
Okay, thank you. So, Chairman, Commissioners, 106G is a different question, right? It is an authorization to the commission to exercise its judgment to refuse to distribute public funding when there's evidence of, in terms of the statute of the rule, fraud or illegal activity. Now, our issues here don't revolve around fraud. They revolve around illegal activity. And the question is whether or not there's evidence of illegal activity. And here, again, you have this question before you on the MUR, but at least for purposes of making a determination on 106G, we have the response, which itself establishes that the PEEP campaign received campaign goods or services before qualifying for funding, and beyond the cash on hand as reported. Rule 104 prohibits a participating candidate from incurring debt beyond cash on hand before qualification. And nothing that we've seen in the response establishes that the campaign had sufficient cash to satisfy its obligation. In fact, the campaign has never once suggested that it did. It doesn't put that into dispute at all. that I'm aware of. And instead, we're dealing with a legal defense there, which is that this is an exemption from a definition of contribution. But the defense doesn't eliminate the evidence of legal activity, particularly where we are, in addition to the 104 issue, we have substantial legal reasons to believe the exemption doesn't apply. So the commission is not being asked, as I read Rule 106G, to make some final finding of liability or impose a penalty. The rule asks whether there's evidence of illegal activity sufficient for the commission to exercise its discretion to not distribute public funds. And I think on the information before us that is the case. So for those reasons, my recommendation is that, and that the commission affirm the withholding under 106A and choose in its own discretion to refuse to fund under 106G at this time. The commission obviously, has the ability to select between those and among them, and I, don't have a position as to whether or not this is an and or an or situation. As my letter communicated yesterday, I believe this is an and or situation. And so that summarizes my comments on the Rule 106 issues, Mr. Chairman.
Thank you, Mr. Collins. Is Dr. Heap here? Mr. Lasota, I see you are. Is Dr. Heap going to appear today?
I think he was joining in, but what difference does that make? I'm here to represent him.
Okay, I wanted to call on Dr. Heap first if he wanted to say anything.
No,
If not, Ms. Lasota.
no, I will do the speaking for Dr. Heap.
Okay, proceed.
Thank you. So you heard Mr. Collins say this is an issue of first impression, which is a nice way of saying the commission has never done this to any other participating candidate. I got the letter from Collins in July. We talked about it last time, and it said, "You've qualified for funding. I'm withholding it. You need to sign an affidavit." Well, we signed the affidavit, and now we're hearing this for the first time. 106AG, whatever it is, which I think is ineffective in the face of a statute, which says specifically 16950, which says if we register for the program, we turn in our signatures, we get funded, period, end of story. I mean, this rule that says that essentially allows the commission to simply withhold money on any evidence of any illegal activity, which is a way of saying if the commission just has a politically disfavored candidate it doesn't want to fund, it doesn't have to fund him. Dr. Heap, when he collected the $5 contributions, the Secretary of State has certified his number as being sufficient. We deserve our money right now, Mr. Chairman. Now, the election's in a month and a half. The early ballots drop in a month and a half. I mean, this thing's not going to wait for another one of the commission's interminable investigations. And that's why we get our money now. And you can conduct your investigation. You can do your thing. I'm sure you'll be hounding Dr. Heap for a long time. But that will be a campaign finance complaint, essentially. We need our money now because we have a campaign to run. You've already told us we cannot withdraw from the program, which I believe is a violation of Dr. Heap's constitutional rights to free speech. So what Tom Collins is saying is you don't get any money and you can't withdraw from the program. And while you're in the program, you can't raise any private money, including your own. And if you do, you're subject to criminal prosecution. I mean, this is like something out of the old Soviet Union. You can enter, but you can't leave. We were told one thing, do X and you'll get your money. You've qualified, but you got to do X and you get your money. Now we did X, and now we're saying, oh, well, there's evidence of and thank you. I guess I should thank Mr. Collins for saying there was no fraud. But any evidence of illegal activity, I mean, That's just not the standard. I know it's in your administrative rule, but it's time to cough up the money for Dr. Heap to run his campaign. Now, in terms of, and oh, by the way, what evidence is there of wrongdoing? I think Mr. Collins had to strain very hard to deal with the our rebuttal to this complaint by a political detractor, and I think it was ineffective. We produced the affidavit from Mr. Torgerson about how he conducts business. Some people pay sooner, some people pay later. I'll just give you an example. I do a lot of candidate petition challenges. I think I do more than anyone in the state. And I just got my last check for challenges that were resolved by about the 1st of May this week. Now, does that mean I made a gift to the candidate? No, I didn't make a gift. Did I loan the candidate money? No. What I did is I extended the candidate credit. Other candidates paid sooner, right? I mean, I prefer it, but I don't control it. And I, this particular person was creditworthy. I wasn't particularly put off by it. I just had to wait. I didn't say, as Mr. Collins suggested, I didn't send someone out. I didn't refer it to a collections agency, so I could claim that was reasonable collection efforts. You saw Mr. Torgerson say it's not overdue. He's not concerned with it. It remains an extension of credit. So you should just dismiss this whole thing, and then you won't have to worry about Mr. Ed. The first thing is there evidence of illegality? So that kind of gets into the third point, but there's a reason I did. It's because it's related, and I too have a hard stop. Nobody bothered to ask us if this was a good time, even though we are the only one on the agenda. I happen to be out of state, but regardless, you should just dismiss this whole thing. I really have very little confidence that you will, but if you don't do that, if you don't give us the money, then what you need to do is and Mr. Chairman, you said at the beginning that I had asked again to be allowed to withdraw from the program. That's not accurate. You turned us down, and I did not ask again. But what I will say is, if you fail in your legal duty to provide the money to Dr. Heap, then yes, you need to release him from the program. I think this commission is on very, very thin ice as it is from a constitutional rights standpoint and First Amendment standpoint, where you're attempting to sway an election by refusing to allow somebody who hasn't taken a dime of your money to withdraw from this clean elections, while at the same time saying, oh, no, no, no. We told you that if you turned in your fives, if you did the affidavit, we'd give you the money. But as a matter of first impression, we are going to withhold it, even though we've never done that before. Never. That's what matter of first impression means. So I think this process is shameful. And with that, I don't know if I'm going to be on for the rest of the item 3. So I pretty much said what I said there, but we have the affidavit for Mr. Torgerson. I know Mr. Collins tries to find what I would call, I think, pretty petty problems with it. I think your rule has to yield in the face of a statute. I just had a case against the clean elections that I won at Superior Court level because the commission, as it often tries to do, is when it doesn't like the statutes, it just writes rules that are better for the commission, and that doesn't work. So your effort, I think, to essentially eradicate this legislative definition, I think not only is it legally ineffective, but I think it does open up an entire new can of worms, because campaigns don't operate on a completely cash and carry basis. If you're going to make your clean elections candidates do that, you're going to put them at a substantial disadvantage. And the irony here is, we've got essentially after the end of 6 months, if an extension of credit has not been collected on, then it does turn into a contribution, and that makes perfect sense. So But that's going to happen just by operation of how the commission has made its decisions. Because if you've got money and extension of credit that needs to be satisfied, but you can't use your own money to pay it, and you can't, and the commission won't give you the money that you've earned by getting $5 contributions, then what's going to happen? Well, by operation of law, that's going to turn into a contribution after 6 months. So I think it just demonstrates again the folly of where the commission has taken us to date. And it's time to give Dr. Heap his money. Absent that, it's time to let him out of the program. Thank you.
Thank you, Mr. Lasota. I'm not going to rebut what you say, but I do take issue with one thing you said, that this is a decision that's based on the political leanings of your client, which is nonsense. What
I said is this would leave that open to that, Mr. Chairman.
Mr. Lasota. The commission has 2 independents, 2 Republicans, 1 Democrat. The political position of your client is immaterial to us. Thank you for your comments. At this time, we will take public comment on this issue. We will ask that speakers identify themselves for the record and limit their comments to no more than 3 minutes. If you're a member of the public and wish to make a comment, please use the raise hand feature in Zoom, and I will call on individuals one at a time. To raise your hand in Zoom, click the react icon in the bottom toolbar and select raise hand. When your name is called, please unmute yourself and state your full name for the record before beginning your comments. Please note that commissioners may have questions for you. Are there any members of the public who wish to make a comment? I see quite a number of them. I will take them in the order that they are on my screen. First is Sorella Barbara Parker. Ms. Parker?
Yes, I'm unmuting now. Can you hear me okay?
Yes, we can.
Yes, and I apologize. It says Sorella. I was living in Rome, and so that was how they were referred to me. Anyway, it's a pleasure to have an opportunity to speak to the commission. Let me just say that no one, I'm sure, is denying that there's a seriousness to compliance issues. No one's asking the court to excuse compliance in any way, or the commission. It's a matter of how we correct mistakes. You know, his first-time candidate, the clean elections is a wonderful opportunity for candidates to run who never would have had a chance to run, and we appreciate that. But it has a lot of rules, reporting deadlines, and accounting procedures, very common. And these kind of accounting errors are common, have happened many, many times before. I mean, I can list many, many times. Garcia, there was Horn, Mendez, Bennett, Kiana Sears, Sherwood, Kathy Hoffman. There's been many, many, many issues of these accounting errors. And it's just a difference of campaign paperwork and a mistake, not a lack of integrity and nothing illegal. Again, the candidate was trying to navigate. But let me just say in conclusion, just for the time's sake, that there's always been a remedy for violations like this, bookkeeping mistakes. And in precedent is before you to again, to have a win-win-win on this. You're going to protect the commission. You're going to protect the clean elections. You're going to protect the taxpayers' money, and protect the choice of the people who overwhelmingly have signed his petition and elected him. So again, all of these errors that are common, that have happened in the past with many, many, many candidates, have been handled by administrative enforcement before, and the situation has been closed. And you have so many avenues to close this and assist this duly elected candidate by, correcting his report. He can certainly repay, even assessing a fine, releasing him from being on clean elections and go traditional. There are so many ways of doing this that's been done in the past. So again, I would encourage the commission to do that. Let's remedy it. Let's put this to bed, protect everyone. We're not, and again, save the taxpayers, saves everybody's taxpayers' time and money, and that's the ultimate key. So thank you for an opportunity to say that. And again, just to quote a couple of these, R2 20206A3 does allow this. He allows him to change. And like I said, let's err on the side of not disenfranchising the voters and take care of this administratively and put it to bed. Thank you for that opportunity.
Thank you, Ms. Parker.
Appreciate it.
The next person I have on my screen is Lisa Everett. Ms. Everett?
Hi, my name is Lisa Everett, and I'm the one that filed the original complaint. Let's face it, signs work. That's why politicians pay thousands and thousands of dollars for these signs. This gave Heap an advantage in this race, and he knew that. The reality is, since I filed my complaint in late June, starting in late July, I started noticing signs disappearing as other people have. They've reported it to the commission, on X, emailed me, called me, etc. And the reality is they're covering this up by removing the signs. So that to me is an admission of guilt. These rules, although they do have a lot of details, they have to be followed. They're in place for a reason, to protect the voters and the other candidates. And we've got to follow those rules. If basic rules for clean elections can't be followed, how in the world can we expect this person to handle all of the very tedious details at the ACC? I'm just deeply concerned that this has gone on, and it troubled me to have to complain about it. But the reality is it happened, and we need to address it. If we don't follow the rules, if we don't enforce them, what good is clean elections? This is taxpayer dollars. I am encouraging all of the board members to vote appropriately. There has to be a consequence to this. So don't release the funds, because we know for a fact the rules were violated. My hope is that for the sake of the voters and the party, that Heap withdraws. But the reality is it's not up to this body. But the reality is the rules were broken. And we, the public, should want the rules to be followed. It's our money. The people that scream election integrity the most need to step up now and start speaking for the integrity of clean elections. Thank you.
Thank you, Ms. Everett. Next, we have Marissa Caldwell.
Hi, thank you. I'm only going to be on audio today. I am a national election integrity expert, so I appreciate the previous speaker wanting election integrity proponents and experts to speak on this. I am also a longtime customer of Mesa Sign Shop, and what Dr. Heap's attorney, Tim Lasota, testified to as far as the relationship with the Mesa Sign Shop is exactly the same relationship that I have experienced with the Mesa Sign Shop. In fact, most recently, there was a mailer that I had them send out, and they mailed it out and didn't even tell me. I found out from other people that it had been mailed out, and they hadn't sent me an invoice or anything yet. And so I don't think that Dr. Ralph Heap should be penalized for a standard business practice of a vendor who does that same business practice with tons of campaigns and tons of organizations across the entire state. I'm a customer going back to 2020 when I ran for Phoenix mayor, and it was a similar arrangement. And so as a candidate, I don't think that it's fair the way that Dr. Ralph Heap has been treated in this. I'm not saying that the commission hasn't been fair. I'm saying that that the rules are ambiguous on this, and I think that I know him personally, and he had no intention of violating anything. I haven't spoken to him on this, but I know him personally. I've known him for a long time, and I know his integrity. And so I do think that the requests that Ralph Heap has made should be met. And I also agree with what his attorney has argued, and I think that all of that should be considered. Also, there are other candidates in this same race who have previously been part of the clean elections. I put in a complaint yesterday because I was, as Ms. Everett said, that she wants to see election integrity people hold candidates accountable to the Clean Election Commission standards. And so I think that this should be all taken into consideration and that there should be justice and fairness. And I have full confidence in the commission that that will occur. Thank you.
Thank you very much, Ms. Caldwell. The next speaker is identified only as Legend. Could you please give your full name for the record? We can't hear you. You're on mute.
Hi, my name is Lara Goodell.
Could you spell that for our court reporter?
R.A. Goodell, Gooddll.
Okay, thank you.
I know Dr. Heap. He's definitely not a fraudster, and Mr. Collins actually pointed that out as well. There was no fraud committed. I really appreciate Mr. Lasota coming on here. I agree with what he said. My first impression of this commission, this is my first time knowing much about it at all. It's not really a good one right now, especially since this is a bit unprecedented. It's never happened before where they withheld the money from Dr. Heap. I voted for Dr. Heap. Me and a lot of my friends, hundreds of thousands of them, it sounds like. So I think we should definitely not disenfranchise what the voters have decided. I think that's very important. That's the most important thing. I don't see any fraud. And if there was any, I'm sure Dr. Heap would have taken care of that. And I just want to say, I hope this isn't an attempt for what the people who lost couldn't accomplish at the ballot box, and they're trying to do it this way. So I stand for a lot of voters, especially up here in Mojave County and all over the state. And we voted him in, and we think the fair thing would be to either release the money to him or release him so he can raise his own funds. Thank you.
Thank you, Ms. Goodell. The next speaker is Beverly Goldstein. Ms. Goldstein? Ms. Goldstein, you're on mute. Ms. Goldstein, we can't hear you.
How about now?
Yes, we can hear you.
Okay. Commissioner, Chair and Commissioners, thank you for allowing me to speak. I wrote out a 5-minute presentation, which I will submit by email. I want to say that I'm representing myself, although I chair a portion of the Republican Party in Pinal County. I'm on here as a private citizen. Ralph Heap received 299,319 votes, and the third place candidate received 16,000 votes fewer. I'm sure everybody on this call is completely familiar with how hard it is to find enough people, take enough of their time to get them to fill out the petition, the Clean Elections petition carefully, and to collect the $5 for each petition. I spent tremendous numbers of hours accomplishing that on behalf of Dr. Heap. I don't know him personally. I met him through going to speeches that he gave regarding his visions for the Corporation Commission, and I support those visions very strongly. And I think administrative rules are valuable, and I don't poo-poo them. But almost 400,000 people went to the ballot box this year and said, I want Dr. Ralph Heap to represent me on the Corporation Commission. And elections are like the top of everything we do, in my opinion. They have to be constitutional, and they have to follow procedures and the laws. But 400,000 people have said, I want this man. So now we're sitting here in a meeting trying to figure out how long we can drag this out so we don't give him any clean elections money and we don't let him do anything with his own money or money that he can collect from people who would be willing to donate to him. I think the most important thing that you folks need to do is decide one way or another that you're going to move forward to do one of these two things, because I don't see this as getting resolved. I'm not going to be satisfied as a voter if the end of this is you don't do either of those two things. And I don't see where there was fraud committed. I don't think I read everything that's available. And maybe there's not a lot available, but I did read the Mesa Sign Shop affidavit, and it sounds to me like the company is doing business with Dr. Heap the same way they do business with everybody else. And you're trying to
Ms.
put that in
Goldstein,
a
could you-
special category.
could
So
you-
I would ask you to just move forward, either give him the money or give him his freedom. Thank you very much.
Thank you, Ms. Goldstein. Next we have Carrie Davis. Mr. Davis? Mr. Davis?
Yes, yes.
Okay.
Can you hear me?
Yes.
Yes, my name is Kerry Davis, and good morning to you, Chairman Kimball. I just want to not reiterate the comments that have already been made, but I would respectfully request that Dr. Heap be released from the Clean Elections program, or you release his money. I think that it's a fairly simple solution to release him from the Clean Elections, or to let him raise his own money and let him bear his own campaign expenses. And so those are my comments regarding this issue. Thank you again for the opportunity to address the commission. Thank you.
Thank you, Mr. Davis. Next, Scott Granger.
Yes, we're here. That's Scott and Maria Granger. I did ask to have my wife's name added, but that didn't seem to happen.
That's okay.
Commissioners and members of the public, we, Scott and Maria Granger, captain and both PCs of Greenfield Precinct LD 10, have the following comments regarding the subject of Dr. Ralph Heap, candidate for Arizona Corporation Commission, as a very successful candidate in the 2026 Republican primary election. We live in a constitutional republic that uses a democratic process to elect our leaders in an election. Such a primary election was held recently. The results, candidate Heap won overwhelmingly against two incumbents. Candidate Heap is now set to represent us in a general election. The Clean Elections Commission has not provided any funds to candidate Heap's campaign. There are no tax dollars to recover, no money that was misspent by candidate Heap. Candidate Heap fully understands that he is responsible for his financial responsibilities. The commission is being weaponized in that it is being used in an attempt to overturn the results of the recent primary election. Candidate Heap won his primary by a healthy margin. We voted for him and have volunteered in support of his campaign to become a member of the Arizona Corporation Commission. Removing candidate Heap from the ballot would not merely punish him, it would negate all of the hundreds of thousands of votes of his supporters that support him. We believe that even an attempt to remove candidate Heap is unjust, anti-democratic, unconstitutional, and very un-American. This also creates a terrible precedent. Unsuccessful candidates and their allies should never be able to weaponize an unelected administrative commission to nullify our votes. This commission should not attempt to keep a candidate, in this case, Dr. Heap, in limbo by refusing to fund candidate Heap while refusing to allow him to leave the program and finance his own campaign with no commission funding. This is particularly onerous when the candidate Heap has met the requirements for commission funding. We voted for Heap and he won the election fair and square without any input from the commission. The commission has no right to steal the hundreds of thousands of votes of his supporters that brought candidate Heap to victory in the primary election.
Mr. Granger, your time has expired.
Thank you for your attention to this matter, Scott and Maria Granger.
Thank you, both Scott and Maria Granger, for your comments.
Thank you.
Next, we have Nick Myers. Mr. Myers?
Yes, thank you. And good morning, Chairman and Commissioners. My name is Nick Myers, and I currently serve as the Chairman of the Arizona Corporation Commission. I am the immediate past candidate in this race, and I'm here today to raise additional concerns regarding the HEAP campaign's compliance with clean elections requirements. I want to start with the most basic rule of the system. The Citizens Clean Elections Candidate Guide states on the very first substantive page what may be the single most fundamental requirement of participating in the program. And I quote, "A participating candidate must adhere to expenditure limits and may not make expenditures in excess of cash on hand. Cash on hand includes both early contributions received and candidate funding." It is presented to every candidate as Rule 1, and by the respondent's own counsel's letter, that rule was broken. I don't believe that's where the concerns end. There have been a number of additional questions raised that simply cannot be resolved without the commission examining the campaign's finances directly. One example, Mr. Heap and his running mate did not file their statement of organization until the night before their public announcement press conference. Yet at that press conference, they already had signs bearing both names in a design and color scheme substantially similar to several other campaigns around the valley, including the Biggs, Farnsworth, and Hendricks campaign in Gilbert. That similarity isn't necessarily improper on its own, but it raises real questions the commission should be positioned to answer. Was there coordination between these campaigns? Was this an independent expenditure or an in-kind contribution? Did the order and timing of that printing violate spending limits or contribution limits? Did the sign printer extend credit for that order? It was placed over a year ago at this point, and I ask whether the invoice for that has even been sent. We won't know until the full financial picture is accounted for. Every receipt and complete timeline of fundraising against spending. It seems clear that the activities supporting these campaigns was coordinated, presumably by a single consultant. While we can't know with certainty until Clean Elections obtains financial records and invoices, it's reasonable to conclude that Jake Hoffman played a central role, given his publicly acknowledgement recruiting of Heap and Marshall, and his role as Mr. Collin and Ms. Yee's consultant, both of whose signs were placed next to each other at the same time as Mr. Heap's. This is, of course, assuming the printing vendor's records reflect what actually occurred. That assumption is exactly what I'd ask the commission to test. The sworn statement submitted by Mesa Sign Shop leaves more questions than answers. It's worth the commission asking directly whether the statements hold up, because the incentives matter here. A relatively unknown first-time statewide candidate is not, in my assessment, the kind of customer that a reputable sign shop would put its business on the line for. Someone
Mr. Myers, your time's expired.
Okay, thank you. Thank you for your attention.
Thank you, Mr. Myers. Next, we have Mary May Beno. Apologize if I mispronounced your name.
Yes, it's Mary May Beno.
Okay, thank you.
Hi, and these are my thoughts. Honestly, I've never seen in my life such vitriol and obsession being directed towards a candidate who just won his primary. Dr. Ralph Heap is a well-respected retired orthopedic surgeon who has even used his skills doing charitable work overseas. He's being accused of not fully reporting campaign costs and of inadvertently making a clean election mistake. But the facts also show that he has never received a dime from any clean elections money, and that there is no taxpayer money to recover. He has asked to be released from this program so that he can finance his own campaign. I voted for Dr. Heap, and not because of any sign. Thousands of other voters put their trust in him to be their choice on the Arizona Corporation Commission. He won by a healthy margin. Please don't take away our voice in this matter. Losing candidates should not use their machinations to pressure this commission to remove Dr. Heap from his general election race. Release him from clean elections and let the voters' choice stand. Thank you for listening.
Thank you very much for your comments. Next is Gina Swoboda. Ms. Swoboda,
Thank you, Mr. Chairman. Can you hear me okay?
can hear you fine. Yes.
Thank you. Thank you, Mr. Chair, members of the commission. I filed a declaration. I just wanted to say that it appears based on the vendor's affidavit that the line of credit reflecting what the candidates council indicates he feels would not become an expenditure until some point in the future, that occurred in April. So we're in August, and to my knowledge, the campaign finance reports have not been amended to reflect what the amount of that line of credit is. It would appear that is to avoid a further rule violation, because based on common reasonable customary costs, it would exceed the amount of cash on hand. So I would ask the commission to make sure that the candidate is fully in compliance should they continue as a clean elections candidate, and that their campaign finance reports need to be amended to reflect all of the expenditures, whether future or current. Thank you so very much.
Thank you, Ms. Swoboda. Next, Linda Patrick Hayes.
Good morning, Mr. Chairman and commission members. I'm going to probably just reiterate what everyone else has said. Thousands of people across the state of Arizona voted for Dr. Heap in this most recent primary. He never spent one dime of clean election money or taxpayers' money for his campaign. Please do not set a precedent with this particular case. Do what the reasonable man would do. If you don't give him the money, then release him from the clean elections. Let Dr. Heap raise his own money, let him pay his own campaign expenses, and don't disenfranchise all of us Arizonas who gave him a primary victory. Thank you so much.
Thank you very much for your comments. Next, Ben Stafford.
All right. Can you hear me?
Can hear you fine, yes.
All right, super. Outside working on a car here. Yeah, I echo what many of the others have here. It seems to be fairly plain to me that you either have to, release him, or just honor what's been done by the voters. We have to recognize that there's a difference between statute and a rule. And as far as I know in my research, he followed all the statutes. Maybe the issue is that rules need to be changed, but you can't change a rule in the middle of a game if this rule seems to be that important. So maybe the commission needs to look at doing that here, I don't know, next year or something. So yeah, I'm a voter. I don't know him personally, but I think I voted, and others I know voted for him because we liked his campaign and what he stands for. So I hope that the votes and the voters will not be ignored. And again, what seems to me the common sense thing to do here, it doesn't appear that there's been fraud here. Those words from the initial, or one of the initial speakers, are really off-putting because that's, especially when you look at the case on its face, fraud is not an issue here. So it'd be helpful if things are talked about plainly and looked at just reasonably and with common sense. I hope that's helpful. Thank you for taking the time to listen to the public here.
Thank you, Mr. Stafford. Next is Alex Logvin. I apologize if I'm not pronouncing that right.
It's good enough. Thank you. Good morning, commissioners. My name is Alex Logvin. I follow Arizona campaign finance closely, and I've spoken to this commission before. Dr. Heap's defense is one idea. The signs were just credit, so nothing has to be reported until the bill gets paid. That falls apart on the facts. Here's the rule that decides this. The clean elections candidate cannot run up debt beyond the cash they have on hand before they qualify for funding. Dr. Heap raised about $17,000. He ordered a statewide sign program before he qualified. And notice what his attorney's 6-page letter never mentions, not once: cash on hand. Not a word. That silences your answer. Even if you take the "it's just credit" story at face value, the law still requires unpaid credit to be listed on every report as an outstanding obligation. Dr. Heap left it off. His own attorney now offers to amend the reports. You don't amend something that was already accurate. Now, before I ask you, I'd like to ask you to focus on something. This whole defense rests on the sworn statement from Jim Torgerson of Mesa Sign Shop. So weigh Mr. Torgerson's credibility carefully, because this isn't the first time he's told a filing officer that paid work was actually free. In his own recent run for Gilbert Town Council, a seat he lost, Mr. Torgerson told the Gilbert Town Clerk that a signature collection company volunteered to gather his petitions. The same collectors were paid by every other candidate who used that firm. He reported it neither as an expense nor an in-kind contribution. The man asking you to trust his sworn word has a habit of using "it was free" to make reportable spending disappear. And that raises a fair question for Mr. Lasota himself. Dr. Heap's campaign finance reports for this entire cycle do not show a single payment to his attorney. We know Mr. Lasota has represented Dr. Heap since at least July 13th, yet Dr. Heap's post-primary report, the one covering July 1st through the 21st, was filed, shows $0 spent. So I'd ask Mr. Lasota to clear something up. Did you also extend Dr. Heap an undocumented line of credit? Is that standard practice for your firm? And if this is pro bono work, or is somebody else paying for it, then there should be an in-kind contribution on Dr. Heap's report dated back at least to July 13th. Right now, there's nothing. The attorney telling you unreported credit is no big deal may be carrying the sum of his own. Mr. Lasota has communicated that Dr. Heap has no intention of filing amended reports to properly document the credit he supposedly received from Mesa Sign Shop. Other speakers today have whined about the clean election rules ad nauseum. If Dr. Heap didn't like the rules, he should not have signed up as a clean candidate. He agreed to these rules multiple times, and that means he agreed to the consequences. I'm sorry, Ralph Heap is not the mayor of Scottsdale, and this is not a photo radar ticket. He can't just ignore the law and avoid consequences. Please find reason to believe continuing withholding the funds and let the investigation do its job. Thank you.
Thank you, Mr. Logvin. Next, Daryl Groves. No, I'm sorry. I apologize. Donnie Bond.
Did I do that right?
Yes, go ahead.
Okay. My name is Donnie Bond. I am an Arizona voter. I am a PC in my area, and I do a lot of other community and political work. But I am representing myself. I just wanted to say that. From what I've understood here, Dr. Heap never received or spent a dime of public funding. And the things that you keep pointing out are that you withheld the funding even though he applied. And to me, it's kind of like asking for a loan for a house, but if you don't give me the money, I don't get the house. So I would just question that he thought he was in limbo, and he's still in limbo. So why would he be reporting anything? Because if he doesn't know, if he has to report it, if you would just allow him to withdraw from clean elections because of maybe the ambiguousness of the understanding of these rules. I do believe that it would be unjust. I am a voter, and many of my whole family voted for him. And just so that you know, I'm fairly new to this, but I also know Justin Heap is his son, and he ran a candidate, for election as well. And so his name is around. And the first thing that I asked was, is he related to Justin Heap? So a lot of us equate one with the other, and whether that's good or bad, but we felt that we trusted one so we could trust the other. So as far as name recognition and being the first candidate, I think that has something that you might consider. I do think, again, that it's unfair to keep him trapped indefinitely, especially since so many voters did elect him. We have put our faith in him. And I would just ask and encourage you to release him from the clean elections, since this was such an ambiguous situation, and let him raise his own money, because then it wouldn't have been an issue at all. And I voted for him. I'm pleased just, don't silence the rest of us on this issue because he obviously did get the votes to be on the ballot. Thank you so much.
Thank you, Ms. Bond. Next, Daryl Gross. Mr. Gross.
Thank you for allowing me to speak. My wife and I voted for Dr. Heap along with thousands of others, and we would implore the commission not to become a vehicle for overturning the choice of voters who have made their decision. And the reason for that is I do believe, from what I've read, that there's ambiguity between the Arizona statutes and the commission's clean elections rules. The underlying commercial credit appears to be lawful. The question is how that credit should have been classified and reported under two overlapping sets of requirements. When you look at the Arizona statutes along the clean election rules, it's understandable that there could be confusion. And but the clean election rule says that some credit must be reported as an expenditure versus credits, and I think it gets confusing. So I understand that. I think that we need to allow some grace and allow Dr. Heap to report at this point and allow him to have the money that he is entitled to. If you look at Arizona statutes, the Arizona law actually allows reporting deficiencies to be corrected. And so I think with that in mind, it seems to me that clean elections should do the same thing in the spirit of that. When you look at the ambiguity between clean election rules and the law itself, I think that there's no reason to think that there was intentional fraud here. And because he received what would be deemed as a credit from the sign company, and that time has not expired yet, I think it's understandable in the way that he reported it. And so I think that you need to hold that into balance. And so I would respectfully ask the commission to be reasonable and allow Dr. Heap the opportunity to cure his reporting deficiency. Let him correct the report and satisfy Rule 106A, and then he can receive his funding. Now, if you don't want to do that, then release him. And then he can clean up his reporting to the Secretary of State, and he can run as self-funded. So we would ask you to make a choice and do one or the other, but don't keep him locked down. Thank you very much for your time.
Thank you, Mr. Gross. Next is Sherry Walton. Ms. Walton.
Hello, good morning.
Good morning.
I'm asking you to do the fair and democratic thing and release Dr. Heap from the Clean Elections Program. He never received or spent a dime of public funding. There are no taxpayer dollars to recover and no public money that was misspent. If there are campaign expenses he must account for, let him pay for himself. What should not happen in this commission to be used as a vehicle to overturn the choice voters already made. He won his primary by a healthy margin. I voted for him. Hundreds of thousands of others voted for him too. Removing him from the ballot now would not merely punish a candidate, it would take away our votes after they were cast and substitute the judgment of a handful of commissioners for the judgment of the electorate. I believe that would be profoundly unjust, anti-democratic, and unconstitutional. It would also create a terrible precedent. Losing candidates and their allies should never be able to weaponize an administrative commission to accomplish after an election what they could not accomplish at the ballot box. The commission also cannot keep a candidate trapped indefinitely, refusing to fund him while refusing to let him leave the program and finance his own campaign. There is a simple and fair solution. Release him from clean elections. Let him raise his own money. Let him bear his own campaign expenses. He never touched clean elections dollars. I voted for Ralph Heap, and this is silencing the hundreds of thousands of people that voted for him and bringing him to victory in the primary election. Most importantly, let the voters' decision stand. Thank you.
Thank you, Ms. Walton. Next, Meg Rubino?
Yes, sir. Thank you, Mr. Chairman and commission members. It's Megan Rubino, PC for Legislative District 10. Dr. Ralph Heap, I'm here for more of a character reference. I've worked with him for many years. And Dr. Heap has just only shown me the utmost respect for his constituents. He's highly respected. His door is always open to any issues I ever had that were extremely important to me. I've worked with him for many years. And I just don't want you guys to take away my vote. I voted for him along with so many others. Please don't silence us. Thank you.
Thank you.
Thank you.
Next is someone identified only as John. John, could you state your last name?
Can you hear me?
Yes, I can hear you. John,
Okay.
what's your last name?
Yeah, I'm sorry. My dogs just see something out there, but my name is John Davison, and I'm a Mesa resident, and I'll voice what many have said here. Number one, thank you so much for allowing us all to speak, and please release Dr. Heap from Clean Elections. That would be the simplest thing to do. Allow him to raise his own money. Let him pay for his own campaign expenses. My goodness. He's never used clean election money. And of course, many have voiced that, and I'm going to voice it also. And I voted for Dr. Heap. My voice and upon thousands of others need to be heard. And please look at this closely. All right, it can be dealt with so simply. And thank you so much for having me. And God bless y'all.
Thank you, Mr. Davidson. Next, we have Tyler Montague. Mr. Montague.
Thank you, Mr. Chairman, members of the commission. I think when you sign up to be a clean elections candidate, you sign up to follow the rules. And I think there are very clear rules violations here and evidence that there may be additional rule violations that could be discovered upon subpoena of various records from vendors. And I think we shouldn't only focus on the signs, but should focus also on the signature gathering process. I submitted a supplement to my original complaint detailing what I think those are. There is solid evidence for professional gathering of at least 45%. Those gatherers, those circulators are also registered paid circulators. And then another additional approximately 40% of the signatures gathered by people who appear to be professional gatherers. That's something that the commission could determine. And also I noted the market value charged by the same vendors to other candidates in the same time period. And that would put that expenditure well beyond what is allowed by the clean elections rules. A further comment, if we can avoid reporting by simply doing all the spending that a candidate does on credit, then I guess we wouldn't have to report anything, right? We could just do it all on credit and not report any of it. And then that can't be it. That's kind of a silly proposition. Furthermore, harm has been done. Other candidates following the rules lost by close margins. This should not be dismissed. I don't even think Dr. Heap has to have had intentions to break the rules, but he did, and harm was done, and so that has to be addressed. Otherwise, the playbook could be come in, sheet the rules. If you don't get caught, great, you get your money. If they catch you, say, oh, I'm sorry, just let me drop out of the program. That can't be it. That's not fair. That's not what the public designed when they created this process and these rules. And so I think for the integrity of the system, the rules should be enforced, and there should be penalties for severely breaking the rules, which is what appears to have happened here. These aren't minor infractions or minor errors. These are significant errors. Thank you.
Thank you, Mr. Montague. Are there any other people who have not yet spoken who wish to speak? I don't have anyone else who I can see has raised a hand. Kathy, do you have anyone else who's asking to speak?
The only other request was in the chat from Jennifer Esposito. I'm not sure if Jennifer is still with us.
Okay, Jennifer, are you there? Jennifer Esposito, I believe. If you're here,
Can you hear me?
I can hear you. Yes.
Yes, thank you. My name is Jennifer. I'm
Okay,
sorry, what?
go ahead, Jennifer.
Thank you. My name is Jennifer Esposito. My husband and I are precinct committeemen in LD 30 in Kingman, Arizona. But I am not speaking in that capacity today. I am speaking as an investigative reporter and as the publisher of an independent newspaper called the Mojave Free Press. I would like to say that Ms. Laura Goodell does not speak for everyone in Mojave County. And for context, I would just like to point out to the commission that she works for Turning Point USA, who endorsed Mr. Heap, and I know that because she was my roommate 2 years ago in training for Turning Point Action, and I was also an employee of that organization. I would like to say that we heard over and over again, ignorance of the law is no excuse. And the Republican Party, says, oh, but we believe in election integrity. And, we always attack the other side if they don't follow the rules. But because Mr. Heap was endorsed by both Turning Point and the Free Enterprise Club, it was not like he was just some ignorant rube candidate who'd never done this before and could not avail himself of advice, could not make a phone call and say, hey, do I need to do something? Or is this legal? Or can I, I don't believe that for a minute. Now, I want to say that I had not met Mr. Heap until June 8th when he spoke at the Kingman Conservative Republican Club of Kingman. And although a lot has been made of the large 4x4 signs, he did have a stack of 18x24 signs that he was handing out at that meeting. I did not know him. I was willing to give him the benefit of the doubt. I even gave him a print copy of my newspaper in case he might be interested in doing any advertising or something prior to the meeting. But when he spoke, my general impression as an investigative reporter and as someone who has run for county supervisor and previously run for the State House of Representative and knows a thing or two about the system was that Mr. Heap was a dishonest person. I mean, maybe he thought he could come to Mojave County and we would not know anything about how the Corporation Commission worked or what they had done over the last few years. But because I've reported on that, I was quite familiar. So I knew that he was not only lying to me, but to the entire room full of Republicans. And that is the reason that I did not vote for him, is because I did not feel he was an honest person. Now, I photographed multiple corners of signs in Kingman, and I notice I pay attention to when signs go up, and which candidates have got theirs up, which candidates are lagging, because I report on these things. And so I noticed that Mr. Heap's signs went up on the same corners at about the same time as the Colladin and Yee signs. And I also know that it's not just the cost of purchasing the signs, but to come out to this far out away from the great megalopolis, you don't pound signs in triple digit heat yourself. You also have the purchase of rebar as well as the labor involved in having someone help.
Ms. Esposito, your time has expired.
Okay, thank you. I just would like to say that thank you very much for giving me the opportunity to speak. And he also had signs in La Paz County. Thank you.
Thank you. I believe we have heard from everyone who wanted to speak. Mr. Lasota, do you want to take 1 or 2 minutes to make any other comments?
Yeah, I mean, I just have a few comments in rebuttal. I mean, I think Miss Everett gave up the game right off the bat, where she says her agenda is to have Dr. Heap withdraw. This is just political. She's still in denial that he won the election, and then Nick Myers joins us again. It's kind of a little bit sad to see the losing candidate who thinks maybe holding out hope that he's going back on the ballot. But I understand he's facing his own complaint, which is one of the things I predicted is that if we're going to adhere to this new rule, I forget what Mr. Collins called it, first impression, we're going to find a lot of people run campaigns the way they run campaigns. They've always run campaigns, but now it's going to be illegal as a matter of first impression. Mr. Logvin, attorney's fees, attorney's fees actually are not contributions or expenditures. But I think we just need to kind of step back and talk. What are we talking here? No free speech and no right to an attorney. I mean, that's just I think that's fundamentally unfair. The last thing, the only person to actually question Dr. Heap's honesty was Miss Esposito, who really does think she's a reporter. She's not. Unless a reporter needs an audience. I thought it was disgusting for her to say that, and she's the only one who has said anything like that. It's baloney. But I think fundamentally we're right back where we are, and it's time to end this enforcement action. It's time to give Dr. Heap his money, and if you won't follow the law in that respect, then it's time to allow him to go raise his own.
Okay.
Thank you.
Thank you, Mr. Lasota. Tom Collins, is there any further remarks you wish to make briefly?
I don't have anything to add unless the commission has questions. I do want to make clear I know there's some hard stops coming up, and so the MUR issue is there, and if the commission determines whether or not we're going to get to that today, that would be helpful to know at some point, not immediately, but we do have a substantive presentation on that. Thank you.
Okay, thank you, Tom. Is there a motion from a member of the commission to go into executive session?
Mr. Chairman, I move that we go into executive session for item 2.
Thank you, Commissioner Werther. Is there a second?
I'll second. Peyton.
Thank you, Commissioner Payton. It's been moved and seconded that we go into executive session. I will call the roll of Commissioner Werther.
Aye.
Commissioner Payton.
Aye.
Commissioner Titla.
Aye.
Commissioner Crump.
Aye.
Chair votes aye. We are going to go into executive session.
Chairman Kimball, I'd just like to confirm it's all commissioners, our court reporter, and Craig Morgan for executive session. Is that correct?
That's correct.
Thank you.
How long will that be?
I can't predict. We'll make it as brief as possible while still addressing issues we need to address.
Oh.
Kathy, are we good to go?
Yes.
Okay, we're back in regular session and we're going to move on to item 3. Review, consideration, discussion, analysis, and possible action on reason to believe in MUR 26-06, Dr. Ralph Heap complaint concerning transactions for political signs, including campaign finance limits and reporting requirements. Tom, are there comments you wish to make on this?
Yes, Mr. Chairman, I do. I think that, the first point is that I'd like to make is that we do believe that there's reason to believe that a violation of the Clean Elections Act and rules may have occurred. So this is reason to believe determination, right? So this is not a decision, an ultimate decision. This is a preliminary determination that the commission makes, and it doesn't address the, does not require it's not a finding of fact, and it's not an appealable agency action. The question is whether there's reason to believe that a violation may have occurred. The complaint here is relatively simple, right? That there were a substantial number of Dr. Heap campaign signs authorized by Dr. Heap, at least by the terms of the signs themselves. And there's no corresponding expenditure to that volume reported in the campaign finance reports. The reports only show one payment to Mesa Sign Shop. And the response, and I would also note in my memo, we outline, what other folks are doing in this context, Mesa Sign Shops, other payments from other candidates and the like, to give evidence of the scope of the issue. And I've not heard yet in the response or anywhere else any discussion from Mr. Lasota about what their estimates are. So what we do know is that Mesa Sign Shop's owner confirmed that the signs were ordered in April and were completed in May, and that the company has not been paid. So there's no dispute about the existence of the transaction. Dr. Heap obtained campaign signs, Mesa Signs produced them. They've not been paid for, and the transaction's not on the campaign's reports. I'd start with the Clean Elections Rule because it is the clearest direct issue. Rule 104D6 says that prior to qualifying for Clean Elections funding, a candidate shall not incur debt or make an expenditure in excess of the cash on hand. Dr. Heap ordered the signs in April. They were completed in May. He didn't qualify until July 20th. Nothing in the response establishes that the campaign had enough cash on hand to pay for those signs. Doesn't tell you and it doesn't tell you the total amount. We know from looking at those campaign finance reports that there's not enough money to cover the ranges that the facts established as we have. And I also know we received a declaration from Ms. Swoboda last night that I distributed to all of you respecting the business practices of Mesa Sign Shop. So that's where we are, right? We have a clear rule that says you must have cash on hand prior to qualification. That's your limit. We have clear evidence that the amount in question is greater than any cash on hand that's ever been reported. And then we have a response that principally focuses on the idea that this is all off the books anyways. So, that's the upshot there. And the memo, and I would point you to it, does get into why we have this rule under Rule 104 and cites the specific statutory basis for that rule. So then we get to the question of whether or not this is a contribution. So let's assume there wasn't a Rule 104 that addressed this directly. Is this a contribution? The fact that the response starts with the premise that it's an exception to a contribution tells us a lot about whether it's a contribution, right? Because if it's not an exception, if it's not a contribution, why would you argue about whether or not it's an exception to the contribution, right? So I think that's an important point to make. But the exemption is not for all credit. The exemption is for credit on a committee's behalf on terms substantially similar to similar extension of credits to non-political debtors. And there must be a commercially reasonable attempt to collect the debt. And I think that when you look at the affidavit from Jim Torgerson on behalf of Mesa Sign Shop, you find that it creates a very clear narrative about what happened here. And that narrative clearly removes this from the exemption. First of all, the statute requires this to be credit extended on the committee's behalf. And I think the easiest way to understand this issue is by analogy, which I've mentioned in my memo. If Dr. Heap went to buy a Buick and wanted to finance it, the lender is going to look at his profession, his income, his financial resources, his personal issue, his ability to repay the loan. And the lender would be extending credit on that basis to Dr. Heap. We wouldn't say that the lender extended credit to his campaign committee because he happened to be a candidate. And Mesa Sign and Mr. Torgerson make that express throughout their throughout his declaration. He talks about Dr. Heap's standing in the commission, in the community. Talks about Dr. Heap's financial wherewithal as a successful doctor. They talked about Dr. Heap's honorableness and trustworthiness. But what there is no assessment of is the committee or his role as a candidate. The committee, as a creditworthiness question, could only repay this conceivably and lawfully, if at all lawfully, right? I'm not conceding it would be lawful, but if it received the money from the Clean Elections Fund. And likewise, Dr. Heap could not pay it off of his own resources as it relates to the committee because he's limited to a very small amount of personal money, $1,910 or something like that, by his voluntary decision to join the Clean Elections program. So that's what we have there. We have a sworn statement from Mr. Torgerson that says, I trust Dr. Ralph Heap because he has the money to repay me for his debts. And that is not the question the statute asks for an exemption. It is, in fact, the opposite of what the statute is talking about. And so it's quite clear that Dr. Heap is not entitled to that exemption. To think about the idea of substantially similar terms, we don't get details on what that we hear in the sworn declaration that I'm telling you, this is what I do. But we don't get any details about what those other transactions look like or what they are. We happen to have another clean candidate whose reports are in the memo who waited until he was authorized by the Secretary of State and then made a purchase from Mesa Sign Shop under the same set of rules. And that reporting by David Richardson, that's what the report should look like. And that's not what Dr. Heap's report looked like at all. We don't have any evidence of any of these contracts, similar or otherwise. We don't have any sense of whether that they're always, just sort of out in the ether. We don't have an explanation for why, if there's a invoice, it hasn't been delivered to Dr. Heap. So we are left with knowledge that there's an invoice that states the value of this. It states this value is exactly what everybody else was charged, but we don't see it. And Dr. Heap apparently hasn't seen it either. I think that all makes the affidavit, where it is express and clear, it is saying things that take it out of the statute, and where we probe beyond that to see how we would assess the substantially similar question, the terms, all those things, we don't hear anything at all. So, we don't need to resolve all these questions of commercially reasonable collection in every circumstance. We need to look at what the affidavit says, what it presents, and what it presents is a business owner making a decision entirely on the basis of the candidate, the person who happens to be a candidate's personal ability to repay. That is not the analysis that the statute calls for. The statute asks, what can the committee do? And then to the extent the candidate's part of the committee, how does he fit into that? Well, he's limited to $1,910. I think that takes it out of it. And so, effectively what the response asked the commission to conclude is the signs existed. There were campaign signs. They were ordered by the candidate, or at least on the candidate's good name. They were produced, they were deployed. Someone incurred an obligation to pay for them, and yet the transaction should appear nowhere. We know the reason that that's supposed to happen is this exemption. We don't qualify there. So then we get to this question of, is there reason to believe that a loan or advance was made and accepted, and whether or not that was lawful? And that loan or advance was not lawful to be accepted by Dr. Heap under 16-941A1, because it was not one of the limited amounts of money that he can take, or resources or in-kind contributions, nor could he personally have paid for it on the terms that Mr. Torgerson testified he expects to be repaid, because he can only donate $1,910 to that same campaign. In other words, there is a side transaction outside of that is Dr. Heap, that is outside of Dr. Heap's obligations to the Clean Elections Act and the obligations he signed up for. And that's not, that is simply not, doesn't fall within the exemptions. It is an advance or loan. It had to be reported. It had to be reported whether or not it was lawful to take. It had to be reported. And that brings you to his obligations under 16-947, where there are, and 16-948, his obligations to do his finances through one account for the campaign, and his obligation to report that properly. So for all those reasons, I don't want to belabor this, I understand the time, but I did want to make those points clear. All of these are briefed extensively in our memo. I think our memo outlines in great detail how other transactions that Mesa Sign Shop operate. They have a specific example of another clean candidate who reported this the way it ought to. And I think that if you hold Mr. Torgerson to his word, which is sworn, that he made this agreement with whatever it is and however it's done with Dr. Heap, because of Dr. Heap's personal ability to repay and personal trustworthiness, it makes emphatically clear that this was not subject to an exemption. This is the kind of loan or advance that must be reported. And there is a reason to believe that it was unlawful to take. So that, I think I'll leave it there unless the commission has any questions.
Okay, any questions for Tom from members of the commission?
Mr. Chairman, I have a question.
Commissioner Crump.
Yeah, thank you. Mr. Collins, I heard in the allegations today during comments, and I think prior to today, that the allegation was that you, on behalf of the commission, said he needs to submit his candidate's affidavit to the commission, and then he'll get his funds released. And it was alleged he did submit his candidate's affidavit, and so therefore now we're bound by that. My question is, can you tell us, I think it's rather brief, what's in the candidate's affidavit, but what those, what he is swearing to, I believe under penalty of perjury, on that candidate's affidavit, for our purposes here.
Yeah, and would you like me to address what was alleged as well, or no? What do you want me to address whether or not what I said to
No, I thank you, Mr. Chairman, but Mr. Collins, what I want to know is really what did he attest to in that candidate's affidavit? Because I believe it is that his financial reporting is true and accurate.
That's correct.
And based on what you've just discussed, in my opinion, it was not.
So, yeah, so the form asks him to attest to the fact that he has filed all campaign reports. It asks him to attest that his campaign reports are complete and accurate, including with respect to vendors and sub-vendors. It asks him to swear that he has complied with all requirements respecting consultants. And then it asks him to attest that he is, and aver that he knows that if he were to file a late campaign finance report, that the commission staff can initiate a repayment obligation if he doesn't tell the commission, the public really, where his clean elections dollars are within the 5-day window, before an enforcement on the Secretary of State's side would start.
Okay, thank you, Mr. Chairman, Mr. Collins. So if I, as one of the commissioners, believe, and I look at the signed candidate affidavit under that subsection A, and I find it not to be true and correct because of this sign and incurring debt, etc. Then would it be logical in your assessment of this subsection G that I could form an opinion that that was either fraudulent or illegal activity?
Well, I think that, yes, I think that if you found that the actual document itself in lieu of the facts was itself an illegal act, essentially, because it does not represent the reality that it swears it represents, I believe that it would be illegal activity. And I will add one other legal point. Under R220-222, were the commission to find reason to believe, the commission can withhold funds under that basis as well. So yes, I think the answer to your question, I agree with you that if you were to swear out something that is true and the evidence is that that's not true, that is illegal activity.
Thank you, Mr. Chairman.
Thank you, Commissioner Crump. Any other questions or comments from members of the commission? Ms. Lasota, do you have any brief comments to make regarding item 3?
I do, and I think Mr. Collins, his attempt to rebut the affidavit continues to fail. It continues to be a moving target. Now he seizes on this. I don't know what he's talking about with this. That there's a difference between the candidate and the candidates committee. I think Mr. Torgerson and anyone else who's actually in business would disagree. And by the way, that's not true that payment is conditioned on qualifying for clean elections, because if he doesn't qualify, then he's not a clean elections candidate and he can raise personal funds. So that's not true. But this whole attempt to draw this distinction between the committee and the candidate is just a total fiction. And it's just, again, it sort of speaks to an agenda here, which is to basically deprive Dr. Heap of his funds. There is a clear agenda. And now I know Mr. Collins thinks that the integrity of clean elections is at stake, but he always thinks that. He starts out his comments with, oh, well, this is really, really preliminary, and, this is not any kind of a finding. There's a whole process, and this is preliminary, and we need to really get into the details. But it's cut off Dr. Heap's money based on that preliminary finding that he poo-poos. So now, in terms of the other thing he doesn't mention is the statute makes a comparison not between political debtors or people who are extended credit debtors is the wrong word, but not between politicals. It makes the distinction between political and non-political. And if you saw Mr. Torgerson's affidavit, it talked about a large institutional investor, large institutional player or that orders signs from him that I think is 120 days overdue. So, again, we shift around. Now we've settled on this distinction, and we have this analogy with buying a Buick. That is just, I don't really even understand what he's saying. It's not true. It's not commercially realistic. It's once again trying to find something to seize on. Now, the last thing I also wanted to say that, if Heap's out, then he can raise personal funds, and he could have withdrawn before, right? Just because he chooses to not go through this process, and he made the application to withdraw before. He could have just decided right in the middle of it he wanted to raise private money, and then he could, in anything that there was an extension of credit on, he could pay with private funds he raised. So I think that. I think we're sort of grasping for a reason to stick it to Dr. Heap as a matter of first impression, a nice euphemism. But Mr. Collins, used at the outset. So I don't know if the fact that we just went straight to item 3 means we're not making a decision on item 1, but I think the committee needs to release the funds, and if it fails to do the job it's legally required to do, then we would ask that he be released from the overall program. And I think this is a word to the wise, especially those of a certain political persuasion about, you might want to think twice about becoming a clean elections candidate, because, and I know what you said, Mr. Chairman, I disagree with you completely. This commission has always been more interested in complaints against Republicans than complaints against Democrats. So I would ask that you release Dr. Healy, release the funds. If you don't, then I would ask that you discharge him from the program. Thank you.
Thank you, Mr. Lasota. Any comments from members of the commission, or does any member of the commission wish to make a motion?
Mr. Chairman, I don't need to go into executive session, but I didn't want to speak for anybody else in case someone else wanted to do that.
I didn't, I haven't heard any motion from anyone that we go into executive session.
Okay, so Mr. Chairman, I wanted to make a motion, but before I did that, I just wanted to thank all those who were speaking today, especially those voters. Specifically, I just wanted to clarify, we were never here to remove anybody from the ballot. I just wanted to make that clarification. This is just about funding. And so my motion would be, there's going to be 2 separate motions, I think is what I think is probably the best course of action. So one is to move to release the clean funding to Dr. Heap pursuant to that rule R2-20-106A. Yeah, that's the first motion.
Okay, thank you, Commissioner Werther. Is there a second? Commissioner Payton, were you seconding that?
I'll second it, yes.
Okay, thank you. It's been moved and seconded that we release the funds to Dr. Heap. I will call the roll. Commissioner Werther.
Okay.
Commissioner Payton.
Aye.
Commissioner Crump.
No.
Chair votes aye. Commissioner Titla had a commitment and had to leave, so the motion passes 3-1. Am I correct about that? Yes. Okay, Commissioner Werther, you said you had a second motion.
Yes, Mr. Chairman, and I'm just trying to make sure I have the right language here for how to do this. Looking at the I'd like to move that the commission finds there is reason to believe that Dr. Heap has violated a statute or rule of which the commission has jurisdiction, and to proceed with an investigation.
Is there a second to Commissioner Werther's motion?
I'll second it, Payton.
Thank you. It's been moved and seconded that we find that there's reason to believe in MUR 26-06 that he has, what, can you
Violated a statute or rule for which the commission has
statute
jurisdiction.
or rule. And it's been moved and seconded. I will call the roll. Commissioner Werther.
Aye.
Commissioner Payton.
Aye.
Commissioner Crump.
Aye.
Chair votes aye. The motion is approved 4-0. We're going to move straight to adjournment. Item 5, adjournment. If there's no further business, I would entertain a motion to adjourn.
Mr. Chairman, I move to adjourn.
Thank you, Commissioner Werther. Is there a second?
I'll second it, Payton.
Thank you, Commissioner Payton. It's moved and seconded that we adjourn. I will call the roll. Commissioner Werther.
Aye.
Commissioner Payton.
Aye.
Commissioner Crump.